Hi, my name is Christina Loback, and I'm an immigration lawyer at CISU Legal Immigration. Today, let's focus on marriage-based green cards for families looking to live together in the U.S. Specifically, let's talk about the Form I-130. The Form I-130 is called the Petition for Alien Relative, and it's the first step in the family or marriage-based green card process. The purpose of this form, and the supporting documents, is to prove to USCIS that a valid family relationship exists between a U.S. citizen or green card holder and the person seeking a green card. For couples, the I-130 is filed to prove that your marriage is both legally valid and genuine. That is, it wasn't entered into for the purpose of obtaining immigration benefits. The person who files the Form I-130 is the U.S. citizen or green card holder. They are called the petitioner or sponsor. The person who is seeking the green card is the beneficiary. U.S. citizens can file the I-130 petition for their spouse, children, parents, and siblings. Green card holders are allowed to file the I-130 petitions for their spouse and unmarried children only. Now, it's important to note here that even if a family relationship exists, there are some situations that will preclude you from filing an I-130 petition for a relative. For example, if you are the sponsor and you obtained a green card or U.S. citizenship through adoption, you can't then file an I-130 for your biological parent. Another example would be step-parents or stepchildren if the marriage that created the step relationship happened after the child's 18th birthday. A third example, which happened with some frequency during the height of the COVID pandemic, are spouses when both spouses were not physically present at the marriage ceremony. So think Zoom weddings. Part of the reason why filing the I-130 petition is important is that it also establishes your priority date for a green card. When the beneficiary qualifies as an immediate relative, they get to skip the line entirely because there are an unlimited number of green cards available. For everyone else, their preference category and priority dates dictate how long they must wait for a green card to become available. For a U.S. citizen sponsor, immediate relatives include the spouse, parent, or unmarried child under the age of 21. Other relatives of U.S. citizens, so married children, children over the age of 21, and brothers and sisters, fall into preference categories, meaning no immediate green card is available. For a U.S. green card holder sponsor, they are unable to sponsor anyone as an immediate relative. So instead, their spouse and unmarried children fall into preference categories and must wait until a green card is available. A really common and quite frankly easy mistake to make when completing the Form I-130 is to leave questions 61 and 62 blank. Now, these are the questions that basically ask, are you applying via consular processing, meaning outside of the U.S., or adjustment of status, so within the U.S.? You have to choose, and in choosing, you need to indicate either the U.S. Embassy or Consulate for consular processing, or the USCIS Office for Adjustment of Status. If you leave this blank, the Form I-130 can still be approved, but the file will just stall because the government won't know what the next step should be. This mistake can be filed by filing yet another form, but it's costly from both a time and money perspective. So, you've determined that you have a qualifying family relationship. What do you need to include with the I-130? Typically, the documents will verify the identity of the sponsor and the beneficiary, including citizenship, prove that a legally valid relationship exists, and will support the bona fides of the relationship. In our next video, we'll dig into the specifics of documents that are typically included in the marriage-based green card application.